Hello. Thank you for your interest in the Executive Office for Immigration Review's Model Hearing Program, and welcome to our Substantive Law Lecture on Asylum, Withholding of Removal under the Immigration and Nationality Act, and Protection under the United Nations Convention Against Torture. I'm Jason Barrows. In this lecture, we will give a basic overview of the legal framework underlying asylum, withholding, and Convention Against Torture claims. Before we begin, a disclaimer. The information provided in this model hearing program lecture is intended solely as an educational resource for attorneys and accredited representatives to improve the quality of advocacy before the immigration courts. The information provided does not replace any EOIR, manual, policy, publication, or case law, and may not be construed to create or limit any rights enforceable by law. Very importantly, the information provided, whether communicated orally or in writing, is not legal advice and does not constitute any legal opinion by the Department of Justice or the Department of Homeland Security. The case scenarios used in the model hearing programs are purely fictional. Any resemblance to actual persons living or dead, or resemblance to actual cases, is coincidental. The information provided in this lecture should not be construed as mandating a particular outcome in any specific case. With that, let's begin. As mentioned earlier, the purpose of this lecture is to provide you with a basic overview of asylum, withholding of removal under the Immigration and Nationality Act, and protection under the United Nations Convention Against Torture. This short lecture is not a comprehensive review of these complex legal topics. We encourage you to learn more by conducting your own research and consulting the relevant legal authorities, including statutes, regulations, and case law. In this lecture, we will first review the basics of asylum law. Next, we will discuss withholding of removal under the Immigration and Nationality Act. Finally, we will provide an overview of protection under the Convention Against Torture. Please note that the information provided in this recorded lecture is accurate based on the law as of October 28, 2021, but the law may have since changed. Before we dive into the substantive law, it's important to know where the substantive law comes from. There are 6 main legal authorities that govern asylum, withholding of removal, and protection under the Convention Against Torture. First, the relevant statutes are contained in the Immigration and Nationality Act, known as the INA, or simply the Act, which is located in Title 8 of the U.S. Code. And second, the relevant regulations are contained in Title 8 of the Code of Federal Regulations, referred to as 8 CFR. Third and fourth, the Board of Immigration Appeals and the Attorney General each issue published decisions that are generally binding on all immigration judges and DHS officers nationwide. Fifth and sixth, most BIA and AG decisions, published and unpublished, are subject to judicial review by the Federal Circuit Courts of Appeals and the United States Supreme Court. While the Supreme Court decisions are binding nationwide, a Circuit Court's published decisions are binding authority on the parties to the decision, the BIA, and the immigration courts within that circuit. Note that the EOIR manuals discourage citing to unpublished state and federal court cases. Now that we know where the law comes from, we're ready for our first topic, asylum. Asylum is a form of relief that a non-citizen may be eligible to apply for if they fear persecution in their home country based on one of the 5 protected grounds, which we will cover soon. When a non-citizen applies for asylum while in removal proceedings, the application is filed with the immigration court and is referred to as a defensive asylum application. This is in contrast to an affirmative asylum application, which is filed outside of removal proceedings with the United States Citizenship and Immigration Services, referred to as USCIS. Note that if USCIS does not grant the asylum application, the applicant may request that the application be referred to the immigration court for review in removal proceedings. If an immigration judge grants an application for asylum, the applicant cannot be removed from the United States. To be eligible for a grant of asylum, an applicant has to prove, among other things, that they meet the statutory definition of a refugee under INA Section 208b1 and 8 CFR Section 1208.13. They must demonstrate that they left their country of nationality, or if they are stateless, the country where they last habitually resided. Further, they must demonstrate that they are unable or unwilling to return to that country, or cannot avail themselves of that country's protection, because they have been persecuted in the past on account of a protected ground, or because they have a well-founded fear that they will be persecuted on account of a protected ground. The 5 protected grounds, as outlined in INA Section 101A42A, are race, religion, nationality, membership in a particular social group, and political opinion. How can an asylum applicant establish that they meet the definition of a refugee? As outlined in 8 CFR Section 1208.13b, a non-citizen may qualify as a refugee either because they suffered past persecution or because they have a well-founded fear of future persecution. Regardless of whether the applicant claims past harm, a fear of future harm, or both, there are 4 statutory elements that an applicant must satisfy to be granted asylum: harm constituting persecution, a protected ground, nexus, and state action. To be granted asylum, an applicant must also satisfy a 5th non-statutory element, that they merit relief as a matter of discretion. We will discuss each element in more detail, but before we do that, let's take a look at what could prevent an individual from being eligible for asylum from the outset. There are several statutory bars that make an applicant either unauthorized to apply for asylum or ineligible to be granted asylum. These bars include 1. The 1-year bar. Anyone seeking asylum is required to apply within 1 year of their last entry into the United States, unless an exception applies. 2. The firm resettlement bar. Anyone who, prior to arriving to the United States, entered another country and while there received an offer of permanent residency, citizenship, or some other type of permanent resettlement is ineligible for asylum unless an exception applies. 3. An aggravated felony bar, which is defined in INA Section 101A43. 4. Knowingly filing a frivolous asylum claim. 5. A previously filed application bar, applicable to applicants whose past asylum applications were denied and not reopened. And 6. The reinstated removal order bar, which is applicable to applicants whose removal orders have been reinstated under INA Section 241A5. Again, these 6 statutory bars only apply to asylum. A non-citizen who is barred from applying for or being granted asylum may still be eligible for withholding of removal under the INA or protection under the Convention Against Torture. However, there are also bars that apply to both asylum and to withholding of removal under the INA. These bars include 1. The persecutor bar. Anyone who participated in the persecution of others on account of a protected ground. 2. The particularly serious crime bar, which includes, among other things, violent or dangerous crime convictions, and in some cases, crimes that are particularly serious even without an actual conviction. 3. The serious non-political crime bar for certain crimes committed outside the United States. 4. The security threat bar, which applies to individuals who may reasonably be regarded as a threat to U.S. security. And 5. The terrorist bar. Individuals who engaged in terrorist activity or who were members of a terrorist organization included in the list published by the Office of the Director of National Intelligence identifying groups that the United States government considers to be terrorist organizations or members of some other organizations, referred to as Tier 3 terrorist organizations, may also be barred. Under these bars, an asylum applicant is ineligible for both asylum, for withholding or removal under the INA before the court. But the applicant may still be eligible for protection under the Convention Against Torture. In deciding whether the bars to asylum or withholding or removal apply to a particular case, please be sure to conduct thorough research and consult the appropriate legal authorities. Note that credibility and corroboration, which we'll discuss in a moment, may affect the outcome of analysis related to an application of certain bars. Now that we have an idea of what bars to look out for, let's turn to the first issue that the court will analyze, regardless of what relief is sought: credibility and corroboration. Credibility and corroboration are threshold issues that must be addressed even before the elements, because they indicate whether an applicant has satisfied their burden of proof. At this point in time, most cases will be governed by the credibility standards contained in the Real ID Act, which provides that an applicant's credible testimony may be enough on its own to satisfy the applicant's burden of proof if it is credible, persuasive, and refers to specific facts sufficient to demonstrate that the applicant has satisfied the applicant's burden of proof. An important takeaway is that credibility alone is not necessarily sufficient to carry one's burden of proof. Even if an applicant testifies credibly, an immigration judge may find that the credible testimony is insufficient to satisfy the burden and require the applicant to submit corroborative evidence. An applicant is required to comply unless the applicant demonstrates that they do not have the evidence and cannot reasonably obtain the evidence. Please note that circuit courts differ on whether an IJ is required to give notice to an applicant before requiring corroboration. Having covered the threshold issues, let's start breaking down the asylum elements. Specifically, let's break down how to establish past persecution. Past persecution focuses on harm that occurred before the asylum applicant left their home country, and the first element we will discuss is harm constituting persecution. What is persecution? According to the Board of Immigration Appeals, persecution is severe harm or suffering that is inflicted with the intent to punish a person for possessing a belief or characteristic that the persecutor seeks to overcome. The severe harm a person suffered or fears may involve physical violence, but physical violence is not required. The harm may be non-physical violence, such as deliberate imposition of severe economic disadvantage, or the deprivation of liberty, food, housing, employment, or education. How is alleged harm assessed? Well, to determine whether a person has suffered harm that constitutes persecution, the immigration judge considers the harm in the aggregate, which is important because an individual instance of harm may not constitute persecution, but that individual instance viewed with other instances of harm might constitute persecution. Generally, actual harm is required to establish past persecution. Some examples of actual harm include physical injuries, financial losses, or property damage. Unfulfilled threats of harm alone are usually not enough to show past persecution, but there are some circuit court cases where unfulfilled threats were found to constitute past persecution, and unfulfilled threats may be indicative that fear of future persecution is well-founded. As we previously touched on, an immigration judge may find that multiple incidents involving actual harm and the threat of harm considered together constitute persecution, especially if these incidents were escalating in nature. To provide more clarity on whether certain harm constitutes persecution, courts have concluded that certain types of harm, without more, generally do not amount to persecution as required by the INA. Always familiarize yourself with up-to-date law in the relevant circuit. That wraps up the first statutory element of asylum, harm constituting persecution. The second statutory element of asylum is establishing a protected ground. As previously mentioned, there are 5 protected grounds: race, religion, nationality, political opinion, and membership in a particular social group. We will look at each of those in turn. The first protected ground is race. Although ethnicity is technically distinct from race and is not itself enumerated as a protected ground, according to United Nations High Commissioner for Refugees Handbook, race should be understood broadly to include all kinds of ethnic groups and ethnic identities that are referred to as races in common usage, including indigenous or tribal affiliations. Note that race sometimes overlaps with nationality as a protected ground. This slide includes an excerpt from the Form I-485, Application to Register Permanent Residence, or Adjust Status, which includes some examples of race and ethnicity. The second protected ground is religion. Examples of persecution on account of religion include severe harm inflicted upon a person for practicing a specific religion, or when a person suffered serious discrimination or received criminal penalties for practicing a certain religion. Third protected ground is nationality, which relates to a person's ties to a particular nation. It is most often determined by a person's place of birth, but it can include ethnicity. The fourth protected ground is political opinion. To claim persecution on account of a political opinion, the applicant must show that they either hold an affirmative political belief or that the persecutor has imputed a political opinion to the applicant. An affirmative political belief is a particular political opinion that a person sincerely holds, whereas an imputed political opinion is based on a persecutor's belief that a person has a particular political opinion, regardless of whether the person actually holds such an opinion. Additionally, INA Section 101A42 explicitly defines certain coercive population control scenarios as persecution on account of a political opinion. These scenarios include when a person has been forced to abort a pregnancy or undergo involuntary sterilization, has been persecuted for failure or refusal to undergo such a procedure, or has been persecuted for other resistance to a coercive population control program. The final protected ground is membership in a particular social group. To establish membership in a particular social group, under current BIA case law, an asylum applicant must show that they were a member of a group that meets 3 requirements: immutability, particularity, and social distinction. The applicant must also delineate the proposed particular social group or groups to the court. These requirements are fleshed out in circuit case law, and there's a lot of difference between circuit interpretations, so be sure to evaluate any specific case under relevant circuit law. We have general explanations noted here, and we'll talk a bit about the BIA's definition. To satisfy immutability requirement, the members of the group must share a common, immutable characteristic that they cannot change or should not be required to change. For example, a person's gender would be an immutable characteristic. To satisfy the particularity requirement, according to the Board of Immigration Appeals, there must be a clear benchmark for determining who falls within the group. A group is not sufficiently particular if it is vague, uncertain, subjective, overbroad, or amorphous. Lastly, to satisfy the social distinction requirement, according to the board, literal or ocular visibility is not required, but the group must be viewed as distinct in the society in question, and the persecutor's perception is not itself enough to determine whether society views the group as socially distinct. Additionally, the proposed social group cannot be circularly defined, which means that the group cannot be defined exclusively by the fact that its members were subjected to the persecutory harm. If the first bullet on this slide looks familiar to you, that's because you've seen it just a few slides ago. According to the statute and regulation, an asylum applicant must show a sufficient link, often referred to as nexus, between the alleged harm and at least one of the protected grounds that we just talked about. Nexus is very important. It is often difficult to talk about nexus without getting into protected ground, but nexus is truly its own element that must be established. It is not enough for an applicant to simply have one of the protected grounds. Rather, to satisfy the nexus requirement, the protected ground must be at least one central reason for the harm that the applicant suffered or fears. Now, turning to the final statutory element of asylum, an applicant must establish state action, in that they need to prove that the claimed harm was inflicted by either the government itself or by a private person or group that the government is unable or unwilling to control. The home country's government includes police officers acting in their official capacity, military, and elected officials. Private entities include gangs, criminals, militias, guerrillas, and spouses. The Board of Immigration Appeals has provided that in determining whether a government is unable or unwilling to control a private entity, immigration judges should consider the government's action or inaction as a whole. Immigration judges may also consider what laws a country has in that area and whether the country is pursuing policies and practices to implement protective or persecutory laws. Let's do a quick recap. To be eligible for a grant of asylum based on past persecution, the applicant must satisfy the threshold credibility and corroboration requirements and must not be subject to any bars. Then, the applicant must satisfy the 4 statutory requirements for asylum. 1, harm constituting persecution. 2, a protected ground. 3, nexus. And 4, state action. When there is a claim of past persecution, there are 2 possible outcomes at this point. Either all 4 elements are established or they're not. If all 4 of the elements have been established, then the applicant has established past persecution, which triggers a rebuttable presumption of a well-founded fear of persecution. And we'll talk about that in just a minute. On the other hand, if even one of the 4 elements has not been established, then the applicant has not established past persecution, and the past persecution inquiry is over. However, the asylum inquiry is not over, because the applicant may be able to meet their burden by separately establishing a well-founded fear of future persecution. Let's turn back to that rebuttable presumption of a well-founded fear that we mentioned a moment ago. What is that? According to 8 CFR section 1208.13b1, if an asylum applicant establishes that they were persecuted in the past, the immigration judge must presume that the asylum applicant has a well-founded fear of future persecution. However, DHS can rebut that presumption by demonstrating by a preponderance of the evidence that either there has been a fundamental change in circumstances, namely that conditions in the applicant's home country have changed so significantly that their fear of return is no longer well-founded, or that the applicant can safely and reasonably relocate to another part of the applicant's home country to avoid future persecution. To rebut on relocation grounds, DHS must show that the asylum applicant is able to relocate within their home country to substantially better conditions than the ones giving rise to their fear, and that relocation is reasonable under the circumstances. So what are the possible outcomes with this rebuttable presumption? That depends on whether DHS rebuts the presumption. If DHS fails to establish a fundamental change in circumstances, or that safe internal relocation is available and reasonable under the circumstances, then the presumption stays in place, and the applicant has established statutory eligibility for asylum, leaving then the issue of discretion. On the other hand, if DHS does rebut the presumption of well-founded fear, then the applicant has not established statutory eligibility for asylum, and therefore cannot be granted asylum. But there is one more option that might be available to them: humanitarian asylum. Humanitarian asylum is detailed in the regulations and is a discretionary form of relief that may be granted even in the absence of a well-founded fear of future persecution. To be eligible, an applicant must have satisfied all of the requirements needed to establish past persecution, and they must also show either compelling reasons for being unable or unwilling to return to their home country, arising out of the severity of the past persecution that they suffered, or that there is a reasonable possibility that they will suffer other serious harm upon removal to that country. A compelling reasons inquiry looks at whether the established past persecution was atrocious in nature. In a other serious harm inquiry, the court will determine whether the applicant has established that there is a reasonable possibility that they will suffer harm that is significant as persecution if they were returned to their home country, regardless of whether that harm would be on account of a protected ground. Note that humanitarian asylum is usually reserved for extreme cases. For example, courts have granted humanitarian asylum in cases involving German Jews of the Holocaust, victims of the Chinese Cultural Revolution, survivors of the Cambodian genocide, and women who were forced to undergo female genital mutilation. So what happens when there is no presumption of a well-founded fear of persecution, and a well-founded fear is considered independently? That's the case when there is no past persecution claimed, or when an applicant fails to satisfy those 4 critical elements for their past persecution claim. To establish that they have a well-founded fear of persecution, an applicant will still need to wrestle with those 4 elements, but it is within the context of fear of future harm instead of harm already inflicted. The United States Supreme Court has held that the standard for determining a well-founded fear of persecution is a reasonable possibility of persecution, which, in numbers, might be as low as 10% chance. In other words, the standard is that an asylum applicant must show that there is at least a 10% chance they will be persecuted in their home country if they were ordered removed to that country. And they can establish that 10% likelihood either by showing that there is a pattern or practice of persecuting people similarly situated to the applicant, or that the applicant will be individually targeted, meaning singled out for persecution. Note that an applicant need not demonstrate that they will be individually targeted if they can demonstrate that there is a pattern or practice in their home country of persecuting similarly situated individuals. Additionally, the applicant must prove that their fear of future harm is subjectively genuine and objectively reasonable. The subjective prong is usually established through an applicant's credible testimony. To show their fear is objectively reasonable, the asylum applicant must show that a reasonable person in their position would fear returning to their home country. Remember that even if the asylum applicant established all of the statutory elements, the court cannot find the applicant has a well-founded fear of future persecution if safe and reasonable internal relocation is available to the applicant. In assessing a claim of well-founded fear of future persecution, the internal relocation analysis is a bit more complicated than when assessing a claim of past persecution. First of all, remember that there is no internal relocation analysis if the applicant fails to establish the 4 elements for well-founded fear of future persecution. But if the elements have been established, we must look to see who the persecutor is. If the persecutor is the government or government-sponsored, then there is a presumption that the internal relocation is unreasonable, and DHS has the burden to rebut that presumption by preponderance of the evidence. On the other hand, if the persecutor is not the government or government-sponsored, then there is a presumption that internal relocation is reasonable, and the applicant bears the burden to prove that relocation is unreasonable under the circumstances. The answer to that inquiry will ultimately determine whether the applicant case moves to the next step, discretion. So now we have gone through credibility and corroboration, potential bars, and the frameworks for establishing past persecution and well-founded fear of future persecution. But there is one more requirement an applicant must meet to be granted asylum. As previously mentioned, an applicant must prove to the judge that they warrant relief as a matter of discretion. In other words, the immigration judge is not required to grant relief even if the applicant has met all the statutory requirements. To support a favorable exercise of discretion, the asylum applicant may submit evidence of good moral character, education records, and other proof that might help support their claim. That's it for asylum. Some key takeaways are: 1. Credibility and corroboration are threshold issues that can be fatal to a claim before the merits, so they need to be taken very seriously. 2. An applicant for asylum is required to prove the 5 elements that we covered. 3. Applicants may claim past persecution, well-founded fear of future persecution, or both. 4. Watch out for shifting burdens depending on whether the applicant has proven past persecution or well-founded fear, and whether the government has been established as the applicant's future persecutor. 5. Remember that there is no well-founded fear of persecution if internal relocation is available. 6. Humanitarian asylum may be granted even in the absence of a well-founded fear of future persecution if the applicant proved past persecution. And 7. The immigration judge has the authority to deny relief even if all statutory elements have been established. Let's now turn to withholding of removal under the INA. So, what is withholding of removal and why would a person apply for it? Well, similar to asylum, withholding of removal is a form of protection. If a non-citizen fears persecution but is ineligible for asylum because of one of the bars we discussed earlier, they may still be eligible for withholding of removal. Unlike asylum, withholding is a mandatory form of relief, meaning that an immigration judge has no discretion to deny relief if an applicant satisfies the threshold, credibility and corroboration issues, and all the statutory requirements, so long as none of the bars to withholding of removal apply. Asylum applicants are eligible to seek adjustment of status to lawful permanent residence if they are admissible. However, applicants granted withholding of removal may not seek adjustment of status. Under the statute and regulations, a non-citizen generally may not be removed to a country if their life or freedom would be threatened in that country because of a protected ground. The 5 protected grounds are the same as the ones in asylum: race, religion, nationality, membership in a particular social group, and political opinion. The applicant must establish a future threat to their life or freedom in the proposed country of removal, which they can accomplish by demonstrating either that they suffered past persecution on account of a protected ground, or that they would be persecuted on account of a protected ground if they were removed to that country. Let's go over the 4 elements of withholding of removal. By the statute and regulation, an applicant must show: 1. It is more likely than not that they will face a future threat to their life or freedom. 2. Nexus. 3. One of the 5 protected grounds. And 4. State action. As you may notice, withholding removal has very similar statutory requirements to asylum, except that the burden of proof is different, which we will discuss in the next slide. For withholding, the applicant must establish that it is more likely than not that they will be subject to persecution upon removal to their home country. The Supreme Court explained that the more likely than not standard requires a greater than 50% chance that the applicant will be subject to persecution, which, as you may recall, is a higher standard of proof than for asylum, since asylum requires only a 10% chance that the applicant would be persecuted upon removal. Because the burden of proof is higher for withholding than it is for asylum, an applicant who fails to satisfy asylum's well-founded fear necessarily will not satisfy withholding's more likely than not standard. Like in asylum, if a withholding applicant establishes that they suffered past persecution, they are entitled to a rebuttable presumption of future threat to life or freedom. Our final topic is the United Nations Convention Against Torture, also known as the CAT. What exactly is the CAT? The Convention Against Torture is an international human rights treaty that aims to prevent torture worldwide. The United States ratified this treaty in 1994. Under the CAT, the United States is not allowed to send a non-citizen back to their home country if it is more likely than not that they will be tortured. In other words, the CAT is a mandatory protection, and if granted, the United States would, if no bars apply, withhold the applicant's removal to the country where it has been established that torture would be likely to occur. Because it is a mandatory form of protection, if the applicant proves eligibility, there is no element of discretion. However, the United States can remove the applicant to a safe third country and could also terminate CAT protection overall if it were established that the applicant were no longer likely to be subject to torture if removed to their home country. Note that credibility and corroboration may also be threshold issues for CAT relief too. To be eligible for protection under the CAT, an applicant must establish that it is more likely than not that they would be tortured if removed to the proposed country of removal. The regulations define torture as an extreme form of cruel, inhuman treatment and does not include lesser forms of cruel, inhuman, or degrading treatment or punishment. The torture must be intentionally inflicted for a prescribed purpose. Prescribed purposes include, but are not limited to, punishment for an act the applicant committed or is suspected of committing, intimidation or coercion, and release of information or pronouncement of a confession. Unlike asylum and withholding under the INA, protection under the CAT does not require nexus to a protected ground. We will talk more about the definition of torture in a moment, but first, what are the eligibility requirements for protection under the CAT? CAT requires a two-step analysis. First, the applicant must show that they will more likely than not be tortured if removed to their home country. Eligibility for CAT protection requires the same high bar as withholding removal under the INA, a greater than 50% chance, but torture rather than persecution. Second, the applicant must show that the torture would be inflicted at the hands of a public official or other person acting in an official capacity or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. Additionally, unlike for asylum and withholding on the removal under the INA, for CAT claims there is no rebuttable presumption of future torture when the past torture is established, or any other burden-shifting framework. For asylum and withholding under the INA, the internal relocation inquiry includes a question about whether relocation is reasonable under the circumstances. In CAT, however, the inquiry is simply whether the applicant could escape torture through internal relocation without regard for reasonableness of such internal relocation. Thus, past torture and the availability of internal relocation are simply factors to be assessed in determining whether it is more likely than not that the applicant will experience torture if they were returned to their home country. Now, let's take a deeper look at what constitutes torture. Torture is an act that causes severe physical or mental pain or suffering, which is intentionally inflicted for a prescribed purpose, by or at the instigation of, or with the consent or acquiescence of a public official or other person acting in an official capacity who has custody or physical control of the victim and not arising from lawful sanctions. In assessing the possibility of future torture, the court looks at several things, such as evidence of past torture, evidence that the applicant can safely relocate within the country of removal, evidence of gross, flagrant, or mass violations of human rights in the country of removal, and any other relevant information regarding conditions in the proposed country of removal. However, usually, mere existence of a consistent pattern of human rights violations in a particular country is insufficient to find that the applicant would more likely than not be tortured upon return to that country. It is also important to note that an applicant cannot string together a series of suppositions to show that torture is more likely than not to occur. Rather, the applicant must prove that each step in the hypothetical chain of events is more likely than not to happen. Turning to the second requirement, who qualifies as a public official? A public official is often an elected official, an on-duty police officer, or an on-duty military officer. But the Attorney General has explained that a person who is not acting under color of law, meaning the person is acting outside of the official scope or duties, is not considered a public official under the CAT. Also, under the second requirement, what is acquiescence? A public official acquiesces when the official is aware of the torture and does not fulfill a legal responsibility to intervene. The Board of Immigration Appeals has held that actual knowledge is not required and that acquiescence may be established through willful blindness. Under the willful blindness standard, the question is whether the government is aware of torture of its citizens by a third party, but is taking no action to intervene. Another relevant inquiry in assessing for acquiescence is whether the government would approve or willfully accept atrocities committed against others who are in the applicant's position. Please be sure to refer to your circuit law for the appropriate standard for assessing whether the government has acquiesced to the alleged torture. If any of the bars to withholding or removal under the Convention Against Torture apply to the non-citizen's case, they may apply for deferral of removal under the CAT. An applicant for deferral bears the burden to meet the same standard of proof in establishing the same elements that we just covered for withholding of removal under the CAT. It must be more likely than not that the applicant will be tortured if removed to the country in question, and the torture must be inflicted at the hands of a public official or other person acting in an official capacity or at the instigation of, or with the consent or acquiescence of, a public official or other person acting in an official capacity. If an immigration judge grants deferral, the applicant's removal is deferred. However, the immigration judge may impose conditions for a grant, and it is possible that the applicant will continue to be detained. DHS can also seek to terminate a grant of deferral of removal under the CAT at any time. This concludes our lecture about asylum, withholding of removal under the INA, and protection under the Convention Against Torture. This reference guide provides a quick summary of the different eligibility requirements. Again, this lecture is intended to provide you with a basic overview of these legal topics so that you can better be prepared to observe related model hearings. It is not legal advice and should not be construed as mandating any particular outcome in any particular case. If you have any additional questions, please consult the appropriate legal authorities. Thank you again for your interest. We hope to see you at one of our live model hearing events or that you enjoy recorded model hearing videos available on I-Corps.